I am not a lawyer, nor do I play one on TV, but I do present digital forensics evidence. So, here we go. The federal rules of evidence are rules that govern what evidence can be introduced in federal courts and how evidence is evaluated. They apply in U.S. federal trials, both civil and criminal, and are designed to ensure evidence is relevant, reliable, and fairly presented to the judge or jury. A quick view here is a brief summary of how the rules play together. And you can see up here, is the evidence relevant? Is 401 to 403? Is testimony reliable or expert opinion? 701, 706. And that'd be like if I testified in a case based on digital evidence I found. Is hearsay allowed or excluded? Rules 801, 807. How do you authenticate documents or recordings? 901 to 903. And then finally, what privileges apply? Attorney-client, etc. Rules 501. We'll be doing a quick review of 4 rules over the next few shorts, covering rules that apply to digital forensics and how we present evidence. But I wanted to introduce the overall guidelines so we have a baseline. Now, each U.S. state has its own rules of evidence that apply in state courts. For example, Texas has their own rules of evidence that I have linked in the description of this video. And because the states basically mirrored the federal rules of evidence, you'll see a lot of similarities. But whose rules apply, when, and where? Well, in federal court cases, we follow, obviously, the federal rules of evidence. In state court cases, we follow our own state's evidence rules. But there is a crossover because in federal courts hearing state law cases, we follow a case based on state law. We use the federal rules of evidence for procedure, but may apply state law for certain privileges or substantive evidentiary issues, basically. So stick around, we're going to get to them because in digital forensics, we follow 4 rules, 701, 702, 901, and 902, and we'll be covering those individually as we continue.